So the attorney for one of the Idaho murder victims has filed an appeal to lift a gag order issued by the judge. That attorney cites First Amendment rights. Judges issuing gag orders typically consider issues like whether or not the public statements will prejudice the jury and whether or not the judge can use other methods to ensure a fair trial, and also whether or not a gag order would address specific problems. So with all that as a backdrop here, I want to bring in criminal defense attorney Phil Holloway out of Atlanta. Phil, good morning to you. Welcome back to our program. Here's what the attorney for Shannon Gray said. Call for number 2, guys. As attorney for one of the victims' families, I'm allowed to relay to the media any of the opinions, views, or statements of those family members regarding any part of the case, as they were allowed to speak about the case under the First Amendment. Do you believe the judge is right in the gag order first? Let's start there, Phil.
Oh, no, absolutely not. Good morning, Bill. Look, these gag orders are what we in the law call a prior restraint of free speech. Now, a prior restraint is basically a court order that tells somebody that, look, you can't go out and talk about something even before you want to do it or before you try to go out and talk about it. So obviously, that's basically like flipping off their switch to their First Amendment, at least as it pertains to this particular case. Now, these things are oftentimes not necessary. And whoever wants a gag order in a case like this has a very high burden to show it's necessary. And the reason I say they're not necessary is really twofold. Prosecutors already, Bill, have a built-in ethical obligation not to try their case in the media or on the courthouse steps, so to speak. Likewise, defense counsel, they have a built-in vested interest in protecting their client's right to a fair trial. So they are not going to go out and say anything in the public or in the media that's going to jeopardize their client's right to a fair trial. And finally, there's also the courts can always change venue or do other things that are less drastic.
Let me get to that last point in a moment here, but the judge is trying to protect, the sanctity of the process itself and make sure that nothing is considered prejudice before the trial begins. You have said we can't presume an unfair trial just because there's intense media and public interest. When you consider the location for this story, how do you find a jury? How do you pick a jury? Everyone's heard about it.
Yeah, of course they have, and that's kind of what my point is. There's going to be media interest no matter what happens. And so to tell this family member that they nor their lawyer can talk about this case is a direct violation of their free speech rights. And we have to balance these things, and of course the right to a fair trial for the state and the defense, those are very important. But look, not only the individuals are impacted here, but the media. The media has it right here to collect the news, to gather the news, and to report the news, and even to come on television and talk about it like we are right now. So these gag orders, like I said, they are presumed to be unconstitutional. And when an appeals court looks at this bill, they are going to start that analysis from that place, the presumption of unconstitutionality. And then whoever wants to keep the order in place is going to have to show that there really is no other way to protect the fair trial rights of the parties involved in this case, and that's going to be very difficult to do.
Phil, we're going to lean on you a lot. The trial does not get underway until the end of June, so we got several months to go here still, and we'll see whether or not the gag order holds and what the judge says about it. Thank you, Phil.